Patty.
Good afternoon, council.
Good
Good
afternoon.
afternoon. Good afternoon.
Do we have everyone here who we anticipate need to be on the call?
I think we do, Your Honor. There's the possibility that Sean Williams may join us, but we can certainly proceed.
All right, so Mr. Starks, I think you were the one who initiated the request on this call with a discovery issue. So tell me what's going on.
So, Judge, I guess to some extent, it's sort of more of the same, at least from my point of view. You may recall, I guess, I don't know, a month or so ago, we were here at that point dealing with APD officers who were not complying with subpoenas and not cooperating, it seems, as it relates to their depositions being requested. That's not the issue so much today. I think the last email that I sent to the court dealt with some written discovery, second request for interrogatories, second request for production of documents. And as I think I outlined in my email with supporting attachments, there was some discovery served on the city where the city failed to answer within the designated period of time, 30 days under the Civil Practice Act. A good faith letter or a good faith email was sent maybe a week or so after the due date. And the city did respond to that discovery following that initial good faith letter. Although the responses that I got, at least from my point of view, and I think when compared to what the Civil Practice Act requires, were incomplete, both with respect to the RPDs and the ROGs. I certainly don't expect or think it's a good use of the court's time to go through all of those different interrogatory responses that we think must be supplemented, or the RPDs where we think documents should be produced. But just by way of example, for some of the RPD responses, the answer that we got was that the city would supplement at some point in time with documents responsive to the request, which is not, I mean, that's not an inappropriate way to respond, but I guess the response that I've asked for, especially given some of the issues we still have in this case, is a definitive date by when the city would provide a response to those RPDs. And so, I mean, one of the issues that's also before the court is a final scheduling order for this case, where the parties could not agree on what amount of time we think is needed to be done with this case, at least from a discovery standpoint. And I mention that because part of the reason that we, at least as the plaintiffs, or that I have requested extended periods of time that I don't typically request or don't have the need to request in other cases, is because in my experience, Judge, and I think some of this you may know from your experience, but in my experience, in the 20 years that I've been litigating cases against the city of Atlanta, some of them which involved Your Honor as counsel for the city, there have always been issues, and this is not, at least at this point, casting aspersions on any of the lawyers. because some of this may just be the bureaucracy of the city. But in my 20 years of litigating cases against the city, hundreds of them, as the court knows, there have always been issues with securing witnesses in a timely manner, producing documents in a timely manner, getting verified responses to interrogatories in a timely manner. We are still having those issues here. And so my request as it relates to this issue regarding the outstanding ROGs and the outstanding RPDs is that what I would ask the court to do, because in my experience, this seems to be the only thing that works, is to require the city to completely and fully supplement its answers to the RPDs and to the ROGs, the second RPDs and ROGs, within a date certain. Because the problem is that if we don't get responses within a date certain or in a timely manner, it's what leads to the problem of not being able to meet discovery deadlines. So the reason we've asked for more time than the city wants for completing discovery is because, in my experience, that always is needed with respect to the city of Atlanta. And so other than sort of going through other examples of how they responded, not providing a verification. The verification obviously is important because I may want to depose that witness. So if I can't get that fact discovery done in a timely manner, which means all of the ROGs and RPDs and depositions taken, I don't have the ability to send to my expert a complete file of the discovery in the case in order to get an expert report back in a timely manner. And so that would be the first issue that's outstanding, is getting a response from the city in a timely manner, consistent with the Civil Practice Act, to this discovery. And so, you know, the last time we were here, I made a point of stating on the record that I didn't believe the issue with these police officers. I didn't attribute that to the lawyers from the standpoint of these officers not cooperating. I can't say that now, though, because responding to this discovery, that's the obligation of the lawyers. And if they can't respond in a timely manner, then they should ask for an extension of time. We never got a request for an extension of time, even to the 48 hours that I gave to say supplement these responses that were provided more than a week late anyway. And frankly, I think under the Civil Practice Act, when you don't respond to discovery at all, I think you waive objections. And I could have come right to the court and said, you know, I want some kind of relief from this. But what I did instead was said, answer these interrogatories and these RPDs. I didn't ask why they weren't answered, or just give us an answer. But then when we got the answer, it was not much of an answer, at least from my point of view. So other than just going through the specifics of the interrogatories and the RPDs, we just want a date certain that's on the record where the court, as well as the plaintiff, can have the expectation that if they are not fully and completely answered, then we can come back to this court and get some kind of relief. So that would be issue number one. But I also have an email that I sent to the court regarding some Clayton County police officers that were duly served with subpoenas, failed to appear for their deposition. I'd like to address that at some point if I could, because that also needs to be done before I can meet at least the deadlines that the court contemplates in a scheduling order for experts to be disclosed. So I can't do that without having the benefit of all the discovery that we're entitled to. So, and I guess the last thing that I want to say is that the city, at least in their response to the court, to my email to the court, bringing this matter to the court's attention, it seemed to be suggested that I was doing something that was outrageous. I mean, they're crying foul about discovery that they didn't answer, that they didn't answer in a timely manner. And so it seems that there was some objection to me saying, answer this discovery in 48 hours. They never requested, well, can we have an additional 48 hours? And so when the 48 hours passed and I got no response, just as I said in the email to them, I would bring the matter to the court's attention. So these are the sort of things that I believe continue to keep us from sort of meeting the deadlines that obviously need to apply to this case. And the only other issue that's outstanding is we have sought to add some additional parties to this lawsuit. I'm going to respond to this with a pleading and putting some things on the record. But I think as the court knows, and I just want to make this proffer because I've never had this discussion with the city, but I do want to say this. We could have just filed that lawsuit and then had two lawsuits for some later discussion about, well, why are we filing two lawsuits when we could have it all together as one lawsuit?
All right, so Mr. Stark, I think that's I'm aware of that motion and the response. I think that's probably beyond what we were noticed to talk about for today. So we're going to have to put a pin in that one.
Very well.
And deal with that one at a future date. I want to focus on the issues in discovery and seeing if we can at least get that issue resolved for today. Let me ask you this, Mr. Stark. So you got the late response to the interrogatories and the document request. Did you get any documents? Are you saying you haven't gotten anything, or that what you've got is you think it's incomplete because the city says it's going to supplement?
I got some documents in response to some RPDs, but there were multiple RPDs, and for some of them, I got no documents at all. And I'm pretty sure there are documents that exist. And it wasn't represented that no documents exist. We've been unable to locate any documents. It's the kind of response that I see when a party needs more time to obtain and gather the documents that are the subject of the RPD.
And you mentioned, and I think when we talked to, and at least one of our prior conferences, we talked about an amended scheduling order. And I think you referenced that you wanted more extended deadlines that the city wasn't willing to agree to. Is that correct?
That's correct. And they submitted.
So we don't have the, as I'm looking at my docket, I don't see a proposed scheduling order, amended scheduling order. And I'm assuming that's because y'all just couldn't get together and agree on what that should look like.
That's correct, Your Honor. And so what we did instead was by email, both plaintiff and the city submitted with all of the enumerated deadlines what our respective proposals were. But you're right. The reason we didn't submit it as a sort of joint consolidated proposal is because we did not agree.
All right.
I got the email. I looked over the argument about the date, so I put in that, which honestly factored in that was
5/20/21. Let me look at that.
which actually favors the case that he put in.
All right, so we've got a case management order that was entered on May the 20th that
and they try to keep more with you because you've always
which I think mostly it, Townsend's telling me, is mostly tracks with your suggestions, Mr. Stark. So
Okay.
we've got let's talk. So we've got those deadlines in place. So given those deadlines, we got to work back from this. If there's information that you need from your expert, the all witnesses shall be deposed no later than August 1st. So I think if we're going to make these deadlines, I think there's got to be some finality at some point before these deadlines come as to what the universe of documents and information is out there. So let me turn to the city and just ask you a question. Do you believe there is more investigation in terms of facts and documents that needs to be done, and that there's more supplementation that needs to happen?
Your Honor, well, I want to answer that question in two ways. In terms of the discovery that has already been produced, I do not think so. A lot of our answers were these documents have already been produced, and we gave the exact base numbers for those videos and documents and items. When there were items that we don't have documents for, we have stated we do not have documents responsive to this. However, we will review our databases and supplement as necessary. And if you look at the discovery responses, that's exactly what it says. So we will continue to review that. We know with police reports and certain things, if you put it in under the wrong number, it may be, you may have to search it a different way if it's not under the correct case number. So that's what we're doing a deeper search, even outside of this specific case, to see if there are any other documents or any other videos that may be a part of this case. But for what we have already given, we've turned over all the videos, we've turned over all the documents that we have, and that's a lot of what our requests for production of document responses are. We turn this over, here's the exact base number. And so to that extent, I honestly am not sure exactly why we're here. If we look at our response to request for production number 1, we say exactly what I just said. These documents, these videos have been produced and this is where they are. That's the base numbers. And if we look at Sam's email from Tuesday, June 8th, he says, identify by base numbers the specific mobile videos and audios that apply to each of the officers identified in request for production of documents number 1. That's exactly what we did. The same with number 2. If we go down to number 7, they said produce responsive data that is consistent with specific documents. We've produced that information and we pointed them directly to it. So honestly, I'm a little confused as to why we're here when we have given them exactly what they have requested. In terms of a verification, we provided a verification for the first set of discovery. And because most of the answers were that the documents have already been produced, we believe that the same verification should stand for both, since these documents are already produced. To the extent that we need to provide another one, we can get another one from a different person in OPS that had that information. But as many of our answers were these documents have already been produced and we pointed to them in the record, I'm not sure that a new verification is necessary.
Your Honor, I'm happy to respond to that. The verification applies to every answer to every set of interrogatories. They have nothing to do with the request for production of documents. So yes, if we submit a second ROG or a third ROG, we're entitled to a verification for that specific ROG. And if the court wants, we can go through, I'm happy to go through all of the ones that we object to as not being completely answered. She's talking about the ones that were arguably completely answered. But we can go through them. For instance,
Well, let me ask this question first. Have y'all had a meeting either on Zoom or had a discussion on the phone, response by response, what you think is deficient and what Ms. Miller thinks is complete? Have you had that discussion?
we have not had.
No,
that.
Your Honor.
All right, y'all have to have that discussion first. I don't think it's productive for me to be mediating this at this point if you have not already had that discussion and say, we have not been able to come to a resolution on this. I'm happy to hear you after you both had the discussion and one side is not satisfied, but I think you got to have that discussion first. And, you know, especially stuff gets lost in translation in emails. Stuff gets lost in translation in letters. And Mr. Starks, when it was you and me going at each other, we got on the phone. We talked in person. And we tried to work out what we could. We couldn't always work it out. Sometimes we had to be in front of the judge, and you know, and that's the way those things go. But I think you got to have a conversation. You know, you don't need to be in person, but you can have a Zoom link and talk about it. You can have a phone, get on the phone and talk about it. I'm going to direct you, both sides, within the next 2 weeks, to have a meet and confer conference on these issues. After that 2-week period, all unresolved issues after that conference, we can have a conference and we'll walk through each one by one.
Sure, that's fine, Your Honor. We could stay on after you get off and have that discussion right now so that we can expedite the time. What I'm submitting to this court, and I hope I'm wrong, is that it's clear from the conversation we're having now that we don't agree on certain aspects of this. But I don't have any problems with going through each of the particular ROGs and RPDs that we have objected to. And I can do that as soon as the court gets off, and then we can send an email to the court saying, we discussed each ROG and RPD, here's where our disagreement remains. I'm willing and would love to do that as soon as we get off with Your Honor.
Well, obviously I'm going to be mindful of everybody's schedule. So if you can do it today, that's fine, but I'm giving you 10 business days to have that discussion and resolve it. You may talk about something and Ms. Miller or Ms. Nair may say, well, you know what, that's a good point. Let me just check this issue and see if we've got more that we think is coming. Or they can just say, no, that's it. That's all you're getting. If you think there's some more out there, then you're welcome to ask the judge to give it to you. It could be either one of those things, or it could be something entirely different, but I want you to at least have had that conversation before I take it up. So I think it will be more meaningful in that context.
Okay, we will do that.
All right. So let's talk about, I think that's your first point. The second issue is depositions of Clayton County officers.
That's correct. So this is a case that involves a pursuit of a motor vehicle that, according to Atlanta Police Department reports, was reported stolen and may be involved in a carjacking or a murder by the individuals in the car. And so within the discovery that I've received from the city of Atlanta, what they have purported to be the justification for following this vehicle and ultimately pursuing this vehicle are reports and information from Clayton County, which I have reason to question as it relates to the discovery that has been done. And so I want an opportunity, because it is legally significant, factually significant to the issues in this case. What information, if any, was APD provided by the Clayton County Police Department regarding this particular vehicle and any crimes that this vehicle or the suspects in this vehicle were involved in?
So you're talking about a discovery request to the city for information related to Clayton County.
No, I'm actually referring to subpoenas and deposition notices of Clayton County police officers to appear for a deposition where they failed to appear, nor provide any response regarding inconvenience or some other date being sought. And so I would like the court's instruction and involvement in securing the presence of these Clayton County Police Department officers who were duly served.
So I think you're gonna need a motion, you're gonna need a motion to compel.
I can do that. I had thought that the court wanted discovery matters, even as to non-parties, brought to the court's attention before filing a motion to compel.
Yeah, I think with non-parties, there's not really any way I can help you because I don't have them before me under my jurisdiction to give them marching orders.
Okay,
But once we've once we've got the motion as to them, hopefully it will get their attention. But I may ultimately have to issue a written order that's saying, you're in violation and you better appear under penalty of sanction.
very, very well, Your Honor. That is certainly one way to proceed. I guess what I was going to request of the court, which I also believe it's within the court's discretion, if these officers were duly served with subpoenas in this case. I'm not asking for any sanctions against them. I am asking for them to appear. And so I believe, I've certainly done this in other cases, that this court could issue an order that essentially says to these officers, having been served and not having appeared, that they should appear on some other date to be determined, or show cause for why they cannot appear. That would essentially be what I will put in the motion. I believe the court has the authority to do that with properly served subpoenas under this case.
I agree with you. I think that needs to be documented in the record.
Okay, very well.
So I will need a formal request, and barring any objection from the city, I want to make sure that y'all are heard on this since you're parties. If aren't any objection from the city, I would enter that order.
Very well. Can I make an alternative suggestion since we have the city here? Although I'm certainly happy to do a motion. Would the court entertain a proposed order from the parties that sort of lays out essentially on the record what I'm suggesting is the relief or the involvement I'd want the court to have?
I don't know that we need that. I think if you just file your motion, no objection. I'm hearing no objection from the city. Let's just get it in, and then I can issue an order, and you can get it out to those folks saying you better appear or else.
Very well.
All right, I think that takes care of all the noticed business for today. I think we're going to have some business in the future. I suspect I will have a hearing on the motion to add parties. There's some interesting issues there that I will want to hear from both sides on. And I suspect we're going to have some unresolved issues after you have your meeting confirmed. So we'll deal with that issue down the line as well.
Very well. Stacy, are you guys willing to stay on and we have this conversation now?
Sam, if you could send us a link that's not streaming live to YouTube, I think that would be a better way to handle that.
Can we do that as soon as we hang up?
Yes.
Okay, very well.
Sounds very good. I wish you all the best of luck in resolving as much as possible so that we don't have to have a 4-hour hearing a few weeks from now.
Thank you.
Thank you, Your Honor.
I take it when
Thank
we
you, Judge Richardson.
Judge, when we are done, do you want a motion if there is some outstanding issues, or do you just want an email?
Just an email, and then we'll put it back on the calendar.
Okay, very well.
Thank
Thank
you.
you very
Thank you,
much.
everybody.
Thank you.
Have a good afternoon.